Welcome to the InfoBrokerWorld podcast, where business intelligence meets global strategy, empowering entrepreneurs with the insights they need to stay ahead.
When a new trademark application is filed, that's not the end of the story. Other businesses have a chance to step in and say, hold on, that mark is too close to mine. This is where trademark opposition comes into play. It's a formal process, but at its core, it's about protecting brand equity, preserving clarity in the marketplace, and preventing confusion among consumers. The most common ground for opposition is what we've already explored, the likelihood of confusion. If the applied for mark is too similar in look, sound, or meaning to an existing one, and it's tied to the same or related goods or services, the law allows the earlier owner to object. That similarity isn't judged just by spelling or logos. It includes phonetic resemblances, conceptual overlap, and the overall commercial impression. Add in overlapping sales channels or shared target audiences, and the risk of confusion rises sharply. Stronger, more distinctive marks, like invented words or brands with global recognition, get especially broad protection. And if there's evidence of actual confusion in the marketplace, that can be powerful proof in an opposition case. But confusion isn't the only basis. There are other important grounds as well. A company can oppose a new application if it owns earlier rights, not just registered trademarks, but also trade names, design rights, copyright, or even protected geographical indications. Bad faith is another ground. If someone files a mark with the intention of blocking a competitor or riding unfairly on another brand's reputation, that can justify an opposition. Then there are absolute grounds for refusal. While trademark offices are supposed to check these automatically, third parties can still raise them. For example, if the mark is purely descriptive, if it's generic, if it's offensive, or if it uses state emblems or other protected symbols without permission, an opposition can challenge it on those bases. In some jurisdictions, there's also a requirement for the opponent to prove genuine use of their own mark. If the earlier mark hasn't been actively used for several years, the opposition could fail, even if the marks are otherwise conflicting. Procedurally, oppositions are administrative rather than full-blown lawsuits, which makes them quicker and more cost-effective. But deadlines are strict, sometimes just 30 days, sometimes 2 or 3 months after publication. Missing that window means moving into cancellation proceedings later, which is slower and more expensive. Many systems also include a cooling-off period, where parties are encouraged to negotiate. Coexistence agreements, narrower lists of goods, or tweaks to brand presentation can often resolve conflicts without a drawn-out battle. Because oppositions move fast and involve detailed legal arguments, professional guidance is essential. Trademark specialists know how to frame the case, marshal the evidence, and navigate the technical requirements. For businesses, this isn't just about winning a legal fight. It's about making sure their brand identity remains clear, strong, and uncontested in a crowded global marketplace.
Thank you for listening to the InfoBrokerWorld podcast. If you have any questions about today's topic, feel free to reach out via the contact details in the show notes. This podcast was created using AI tools. If you're interested in producing your own AI-driven podcast, from concept to audio, feel free to get in touch. We'd love to hear from you. Until next time, stay informed and stay ahead.